Members, it's the appointed time and we have a quorum. Let me call the meeting to order. First, we need to elect the chairman. Mr. Ronnie Tong, nomination. Mr. Kenneth or Dennis Kwok, do you accept nomination? Yes, I do. Any seconder? Any seconder? Mr. Wong, seconds. Any other nominations? If not, I declare Mr. Dennis Kwok returned chairman. Members, do we need a deputy chairman? No? Okay. I call the meeting to order now. Can we invite the administration team to come in?
Okay. 其實都唔使開到4點半應該。唔使㗎，如果你話覺得係時候要停咪得咯，我哋再約下次，因為下次咧要同你再夾時。因為我諗今日撞得好犀利，我哋4個會。我哋知啊，因為已經冇晒日子嘅。我知道。3、4點攞晒嚟就開。係啊，唉，有慘。Hello， 歡迎。
Welcome。
歡迎。Hello。
請佢哋介紹下，咁我哋議員有冇提問？好。
歡迎。
Let's welcome members of the administration team. Which of you will be introducing the paper, please? Mr. Lee, please. Thank you, Chairman. This is the Administration of Justice Miscellaneous Provisions Bill 2014, and there are 6 amendments. Number 1, it has to do with appeals in civil causes or matters to the Court of Final Appeal. At present, this is a civil cause or matter lying to the CFA as of right. We think this is not ideal, so we'd like to make amendments to the ordinance. So all civil appeal need to be decided by the discretion of the Court of Appeal or the CFA, in other words, subject to discretionary relief. Second, evidence taking by live television links for criminal proceedings. The term live television link is defined in the law. This is for the gathering of evidence, but then this is very narrow and it actually points just to CCTV. We'd like to expand this so that we can enable other suitable audiovisual facilities to be adopted. Number 3, mode of delivery of reasons for verdicts in criminal proceedings in the district court. We are talking about reasons for verdict. At present, the district court must orally deliver the verdict. But we are going to give the flexibility to judges later. Where appropriate, the reasons for a verdict can be given in writing. Number 4, calculation of qualifying experience for appointment of permanent magistrates. At present, the law says that there should be not less than 5 years professional experience. You must be a barrister, solicitor, or advocate in a court, or you must be a legal officer, or you hold positions in particular government offices, or you are a special magistrate. Right now, only the first 2, in other words, that you are barrister, solicitor, or advocate, or that you are a legal officer, or you have taken up offices specified in the magistrate's ordinance. These experiences can be included, but then your years as a special magistrate will not be included. In fact, the policy intent is to allow all 3 types to be calculable as the required professional experience for the appointment of permanent magistrate. So we're going to propose this amendment so that we can allow all 3 types of legal practice or service to be calculated. Number 5, operation of the Labour Tribunal. There are 3 parts. We'd like to clarify the jurisdiction, enhance case management powers, and align the time limit for enforcing awards or orders. The last one, administration of suitors' funds. At present, the CFA, the Lands Tribunal, the Labour Tribunal, Small Claims Tribunal, the High Court, and the District Court all set up suitors' funds. And the operation is dictated by certain subsidiary legislation. The CFA and the Lands Tribunal, however, do this administratively only. So we're going to make an amendment to the law to state in a clearer way that the relevant laws and tribunals will be able to make rules. After the amendment is made, we will make subsidiary legislation to improve the present operating mechanism and also make new dedicated suitors' funds rules. When we formulated these amendments, we actually already consulted the Bar Association, the Law Association, and also the Law Society, and also the Labour Advisory Board, as well as the AJLS panel. And we have made such amendments after consulting them. The present bill reflects that situation. Thank you, Chairman. Members, the floor is now open for you to ask questions. Mr. Ronnie Tong. Chairman, the CFA is saying that it will cancel its right to allow appeals automatically without having regard to the amount involved. I'm a little worried about that because under the CFAO now, the leave to appeal is held in a very strict way. And very frankly, most of the cases seeking leave to appeal, in fact, do not comply with the standards in the present law. In other words, that there should be it must be of general public importance. If there is a substantial appeal power, then the CFA should be dealing with cases which, well, I'm not exactly talking about the strict requirements under Section 24, but I would say that these cases must have more worth than having the CFA granting appeal all the time. If you say $1 million is too low a threshold, then you can heighten it, or you can make another provision providing for a lower threshold. Because in certain important cases, well, they may not have to do with great general or public importance, but they may involve huge amounts of money or very important rights. However, the law point may be attending to that particular case alone. If those cases are not going to be going to the CFA, then I don't know what the CFA can do. The CFA can sit there all day without doing anything. So if you want to amend the as of right clause, then you should put in some replacement, and the replacement can be worded in such a way that it requires a lower threshold or a relaxed standard than the present stipulation. However, I don't think you should cancel all cases of all types unless you also amend Section 24, if I remember correctly, because there are two reasons provided under Section 24. But I don't see that to be what you are proposing to do. Therefore, I think what you are proposing is unacceptable. Can I ask the Judiciary? to comment on this point, especially on that point of as of right. Actually, at the panel, some members have already registered their concern. Yes, Chairman, as I also explained in the panel, our Court of Final Appeal is not a second appeal court. Therefore, we need to consider one principle in dealing with this matter. And that is, why should we have an amount of 1 million or 10 million for that matter, or any other amount? And that is, if the matter in dispute amounts to or is of value of $1 million or more, then you will have the leave as of right. Now, we don't think that should be the case, and that is why we don't think we should still include that dollar amount. Now that there is no provision of as of right, it still doesn't mean that cases cannot get leave of appeal to the CFA. And they will just follow other civil cases, and in that the CFA would be able to provide or allow leave to appeal from case to case. But the member's point of a great general or public importance is relevant because that has been with us for a long time. Actually, in the present system, we have the words or otherwise. In other words, the CFA, where appropriate, can still grant leave to appeal. And we have no intention to change those two criteria in this amendment exercise. Mr. Ronnie Tong. Sorry, Chairman. Of course, I understand those two reasons for appeal. I have been a legislator for 10 years, and therefore in these 10 years I have not been taking too many cases to court. But then, as far as I remember, for the many times I have been to the CFA, I have never been able to get the leave to appeal under Section 24(2), in other words, under the ground or otherwise. In other words, the criterion stated by the CFA is such that or otherwise would only apply where there is no great general or public importance. In other words, the judgment by a lower court has to be really very wrong before it can be used. In other words, this is still too strict, too harsh. If you don't change it, we will have no way to immediately understand under what circumstances the appellant can appeal. You are shirking the responsibility to the CFA, which may take 5, 10, 15, 20 years before it can precipitate some guidelines or criteria for such cases, so that appellants will be able to rely on those case law in order to know which cases can be the subject of appeal and which cases cannot. I think your present exercise is totally irresponsible, and I hope you will go back and think about this again. I can understand that it is not very appropriate to set a dollar amount to it, but if you do not amend Section 24, I really cannot accept it. Anything to add? Nothing more from me. Mr. Yu Si Wing, Chairman. $1 million is really not a big sum in present-day Hong Kong. If any case that has a dollar tag of $1 million will automatically go to the CFA, that is not something good, and I believe we should gradually change it. But then the present mechanism has 4 downsides. 1, uncertainty. 2, delay. 3, extra legal cost. And 4, the other party, which may also have a reason, will not be able to get justice. In other words, the present mechanism is fallible in these 4 issues.
I would like to know the probability of these happening. Uncertainty, how many cases? Delays, how bad are the delays? And rendering, therefore, that the sentences or the case problematic. Do we have data at all concerning these 4 possible occurrences? Thank you, Mr. Chair. We talked about the 4 areas. In fact, there is no data to illustrate them because we do not have hard and fast rules as to how we differentiate what constitutes a delay or not. But of course, if you provide a right of appeal to a party, But because of the possession of that right of party, but without sufficient basis, the party raises an appeal when in fact the case should have come to a conclusion, and therefore the other party is not served the justice that is due him or her on a timely basis. Now, of course, we are concerned that the party that brings the appeal should have his or her right, but on the other hand, we have to consider the other party as well. If the other party, or if the party bringing up the appeal, not because of sufficient basis or merits of the case, but simply because of possession of right of appeal, and the other party is not given justice on a timely basis, that would not be right. Mr. Chair, I would like to know how long has this mechanism been in place for? Mr. Chair, actually, before the return of sovereignty, it was already in place, and in 1997, when we came up with the CFA bill, we have maintained or kept this particular mechanism. So from then till now, this mechanism had been in place and operational. Well, that's well over 10 years, almost 20 years. We talk about these 4 areas leading to injustice. I would think at least we should have some data or conditions that we would know about. According to your experience, for such situations arising, if you say that you do not have the data or statistics, if we want to make the change, if indeed we want to, I think it would be nebulous, or we do not have very clear basis to do so. Well, Mr. Chair, I probably would not be able to come up with the specific data as suggested by the member, but we do have some figures accumulated over the past 4 years or so by the administration. Now, what are the figures you're talking about? That is starting from 2008 to 2012 for the cases handled in the CFA that are based on right of appeal. Yes, that's exactly the data I provided to the meeting on the 28th of January. Yes, we have provided some information and data there. Can you please give us the information again? Yes, I will do so. Mr. Chair, for the 4 areas, you may not have data for all of them, but at least you would have some information as to the cases whereby there had been delays or whereby extra legal costs had been incurred. Mr. Chair, well, delays, how do we define delays? That is very difficult indeed. But if you're talking about appeal cases based on right of appeal, and the leave that's granted or not granted by the CFA in the end, we have such data. Mr. Chair, I have another question. Mr. Tong had talked about if we change the mechanism, the CFA may have their workload reduced. Well, to what extent, I would like to know. Is it quite saturated at the moment? Well, Mr. Chair, we are dealing with this matter purely on principle. We are not thinking about how we are to reduce the workload of the CFA. Mr. Ronnie Tong. Mr. Chair, just to follow up on the question raised just now by a colleague. Since the return of sovereignty, for the number of cases that have been successful in lodging an appeal. Well, there are 2 types of such cases, right? The cases based on right of appeal, and secondly, on the basis of Section 24, what are the number of cases or percentage of cases that were successful in getting leave? And therefore, you would know of such numbers and therefore the workload, wouldn't you? Well, actually, in the January meeting of the panel, For the data we provided, it was data gleaned from 2008 to 2012, and it was data obtained on the basis of the number of cases lodged with the CFA. But on the other hand, we have not. No, I think you misunderstood me. Every time there is an appeal, since 1997, well, first of all, you have the number of cases heard by the CFA. You have that number, don't you? Yes, indeed. Now, there are two factors there. One, those that are automatic, according to Section 23, and next, those that were brought to the CFA according to Section 24. My question is, how many cases were actually brought to the CFA with leave? And therefore, you get the workload. And secondly, you will also have the number of cases that were based on Section 24, heard by the CFA. And by so doing, you would know the number of cases or the proportion of cases that were brought to the CFA based on Section 24. According to my understanding, they are very few and far between, probably 2 or 3 out of 10. And therefore, the success rate, one can say, is very low. Do you have such numbers, Mr. Lee? For civil cases, 2012, we are really talking about 27% for those who finally get the leave. Well, I'm talking about leave of application, not cases that have been successful in getting award from the CFA. Well, would you please provide the information after the meeting? We're talking about the success rate for leave of appeal, that is, leave given by the CFA. Mr. Tong? Well, Mr. Chair, actually, I think without this automatic mechanism, this right of appeal cases, one would know the workload impact on the CFA. It would be clear. Ms. Leung Mei-fan? Mr. Chair, actually, the panel meeting had discussed this matter at length. On the 3rd of December, we have met with the judges of the CFA, and in different fora, members have raised their concern concerning this amendment. And there is a general principle, and that is the financial limit should be quite objectionable as a matter of principle for linking with the right of appeal. But I've raised many times before, and that is if we abolish this particular mechanism, it is felt by some that the probability of bringing an appeal to the CFA would be lowered. And as Mr. Ronnie Tong had mentioned, we should have numbers concerning that. Would you please provide them as soon as possible? Now, as for the judiciary's workload, I think we are all agreeable in the panel, and that is we should add or provide more resources so that you have more hands on board to help with the appellants or the appeal cases. And so that there can be these cases, including the cases linked to right of appeal, can be dealt with efficiently. Now, I heard from the discussion just now that we are not very happy, or the colleagues are not very happy, that you're still not able to provide us with the data and the numbers because it's been a few months. I personally hold an open stance. Indeed, I have heard many saying that there should not really be an arbitrary financial limit to and link that with the right of appeal. I think that is problematic. Yes. Anything else? Mr. Ronnie Tong. Just one other point, Mr. Chair. For the success rate of appeal cases brought to the CFA, I think that is relevant as well. If we look at common law jurisdictions around us, the success rate is relatively low. By that I mean, now let me rephrase. For cases that reach the CFA, the number of cases that are successful is relatively low. That's what I was trying to say. And meaning that the Court of Appeals rate of or instances of making errors is low, and therefore the success cases in the appeal cases that are successful at the CFA level would be low. My question is the success cases incidence more or less the same, that is low, as compared to the other common law jurisdictions? I would like to know whether our courts of appeal reach that particular standard. Because if they do not reach the relevant standard, then there would be more CFA cases or appellant cases, and the appeal cases would be more prevalent. That would show that the reliability and the reliability of the courts of appeal are not that high. And that is why we have to be very careful in considering this amendment. Otherwise, the cases that are wrongly decided by the Court of Appeal would have no other for further deliberation. And that is a point I would like to bring to the attention of colleagues. Mr. Chair, for dealing in any particular case, the judges will follow the laws in considering the cases. For Mr. Ronnie Tang's point, having looked at other jurisdictions, there is no data on the credibility of the courts. And we're looking at the past years' data. We do not have the numbers concerning successful cases versus unsuccessful cases. But in the paper, we have also pointed out that we have to be careful in looking at and interpreting such data. Otherwise, we may draw erroneous conclusions. Mr. Wang Yukman. Thank you, Mr. Chair. Concerning these 6 parts, I have certain opinions. I am in favor of some of them, but if we look at the details, I have some problems. For example, in Part 2, concerning CCTV coverage of or live television link as defined in Section 79, and which is a system in the courtroom and another room located in the same premises as a courtroom being equipped with such live television's link. This will enhance the efficiency, and I agree with that. For other suitable audiovisual facilities, such as video conferencing facilities, how do we satisfy that? Well, actually, the legal advisor had also raised the same question, and that is concerning the interception of the video link for criminal hearings. And also for the district courts in terms of the verbal reading out of the judgments. Rather than to request for that, the judges at the district courts should be, or magistrates at the district court, should be able to rely on written judgments. I should be in agreement with that. Now I'm looking at Section 80 written judgments. The copies must be given to both parties and be lodged with the library of the High Court and also be lodged with the register of the High Court for public referral. All these are suitable so that the parties concerned and the public will have the information in order to protect and maintain the spirit of rule of law, and I'm in agreement to all those. Now, for Section 80, for verbal or written format of delivering the judgments, what are the factors to be considered? Perhaps for Section 80, we should specify that there are factors to be spelled out as to which mode is to be used.
Well, I understand that when the court decides on the relevant mode of delivery, it should give consideration to the wishes of the different parties. And if all of them would still like to have an oral delivery of the verdict, then I think the district court judge should still deliver the verdict in an oral form. And also, as for the CFA part, I still have some views to express. This is about the as of right situation, and that is to take any civil appeal to the CFA as of right. I can see from the Judiciary Administrator saying that in 2012, out of the 27 taken to the CFA, 6 were done under this particular arrangement of as of right, and 2 were upheld. In 2008 to 2012, with regard to criminal and civil cases seeking leave to appeal, CFA only allowed a very small proportion, which is about 12 to 28% only. I believe justice cannot be weighed just by figures. One wrongly decided upon case is one too many. And under the common law, the higher courts have a binding effect on the lower courts. So you cannot say that this can be dismissed because of the small numbers. Therefore, with regard to this taking away of the as of right mechanism, I have some reservations. I think they can answer my questions if they still remember them. I do remember them. First, the district court ordinance, and when the judge will deliver the verdict orally or in writing. We have conducted internal consultation. When a district court judge decides on whether they would like to do it orally or in writing, they would consider how long it will take to deliver it in an oral form, how complicated the case is, and whether the two parties have got legal representation and their background, say whether they have special requirements, etc. Therefore, the circumstances differ from case to case, and it will be very difficult to list so-called relevant factors in the ordinance. Our inclination is to just allow flexibility to district judges who will act according to the wishes of the litigants and other factors as proposed, and then the district judge will make his own judgment. As for the CFA matter, after the meeting, we are going to furnish members with some figures. This time around, we are talking about removing the as of right situation, but it doesn't mean that there will be no opportunity for appeal. It is just that an application for leave to appeal will have to be made to the CFA. When processing such applications, the CFA will certainly carefully look at the cases concerned, whether they are of great general or public importance. And also in the ordinance, there are other reasons for the CFA to consider the applications favorably. There was another matter raised, and that is the criminal procedure ordinance and the CCTV wording, for that to be changed to other suitable audiovisual facilities. Indeed, as the member mentioned, this is to provide flexibility. Right now, there may be just one room where you can allow evidence to be gathered through CCTV. But later on, if we can have other audiovisual facilities, then we will have more flexibility and latitude in order to take care of the workload. The legal advisor also mentioned the security point. Internally, we are doing some consultation in launching the new mechanism. Certainly, we have to first of all put in place appropriate facilities and arrangements. After the meeting, we will take the matter up with the LA as soon as possible, and that will be through writing. Mr. Wong, can I respond, please? To the Deputy Judiciary Administrator, I'm talking about the point with regard to the CFA. The present amendment is that for all civil causes or matters, whether or not the dispute amounts is or of the value of $1 million, all that would be subject to discretionary consideration by the CFA or Court of Appeal. Originally, there was the setting of this amount, and it could be traced to a Privy Council order. It was set in 1995, and from then 19 years have passed, and it has not been revised according to inflation. So I think it is time for us to review the arrangement, no matter whether we are for or against it. But I cannot agree that we should do this to lessen the workload of the CFA. First of all, you have to consider the point whether the rule of law is upheld, and especially when people can only go to the CFA, and that is the dead end, so to speak. And even if there will be a high workload and it means a longer wait, so what? And compared to other courts, the CFA doesn't have that big a caseload anyway. And on the odd occasion when there is not a lot of reason, I'm sure the CFA can dismiss it very soon. And of course, the parties will have to take up the legal costs, but, well, of course they have to. If you take a case to the CFA, not everybody will get legal aid. And the parties would, first of all, give this enough consideration. And so we do not really have to worry that the as of right setup would be abused. Mr. Lee, any supplement? We are proposing this amendment not really to lessen the workload of the CFA. Well, if that will be one of the consequences, then that will only be an indirect consequence. From the angle of justice, why should we set the dispute amount at $1 million and then you would have the right automatically, and not so if the amount is lower than $1 million? We would like to do a review from that angle. In 1995, the Privy Council made an order, and at that time, the amount was set at $500,000. When we worked on the CFA ordinance draft, we increased it to $1 million. That is by way of information supplement. In other words, the $1 million amount was set in 1995. Is that right? Yes. Yes. When we were drafting the CFAO, we preserved the as of right mechanism, but we increased the $500,000 amount to $1 million. And when we worked on this amendment exercise, we also looked at other common law jurisdictions and what their arrangements were. And none of them still preserved that as of right mechanism. So Hong Kong is the only common law jurisdiction which has maintained this mechanism of as of right. Thank you. Mr. Yu Si-wing. Thank you, Chairman. With regard to the district judge, who will now be given the flexibility to consider delivering the verdict in writing under the Criminal Procedure Ordinance. In other words, the district judge may now not only deliver the verdict orally. Well, I agree that if the case is a protracted one, And if the judge has to read out every word of the verdict, it will take a long time. But if the judge can now decide not to read out the reasons for the verdict, I think the flexibility is too much. I think at least the judge should give the main considerations behind a verdict. In other words, the gist of his judgment should be read out. The judge may be very busy, and he will just hand you the judgment. In other words, he doesn't even have the responsibility to read out the main points of the verdict. Now, I don't think that should be right. At least he should explain the main points in the verdict orally. Thank you, Chairman. At present, the requirement is too rigid because no matter what, the district judge is obliged to read out the verdict. And on certain occasions, the judge did spend a day or two just on reading out the verdict. And this is also costs for the litigants. What we are proposing is that there will be this latitude for the judge, where appropriate, to decide whether he would like to deliver the verdict in writing. We have written in our paper that it is not just to release the reasons for verdict. The judge also has the responsibility to give a copy of the reasons of verdict to the parties. And also from the angle of legal justice, the judgment should also be lodged in the High Court Library and the Judiciary's website. In other words, it will not be that the judge is too busy, so he resorts to delivering his verdict in writing. However, there will be formal arrangements to entrench the delivering of the reasons for verdict in writing. Mr. Yu, Chairman, normally, if it is a simple case, the judge will just have to say a few sentences and that will be it. But if it is a major case, and if the parties involved are not exactly conversant with the law, and these people will not have the chance to listen to the verdict in the court, it will be too difficult for them to read the verdict. So in my view, the judge has at least the responsibility to explain the main reasons for the verdict orally. Or else, if all flexibility is given to the judge, I think this will dampen the public's right to know. Perhaps you can clarify this a little to say that the judge can decide to read out the verdict or the main points depending on the verdict itself. In other words, he should explain his verdict in simple language for all to understand. Because if it is a major case and then you just issue a verdict which is as thick as a book and ask everybody just to read it, I think that is not very responsible. So would you like to clarify this and reword it a little? Thank you, Chairman. When a court deals with a case, if the judge has reached a verdict, whether it is read out or delivered in writing, there is no difference. That would represent what the judge wants to say about that case. So there is no question of asking the judge to write a summary of the verdict. And there is no question of asking the judge to deliver the summary orally. I think that will be difficult. I would say, if it is a simple case, and if the judge can deliver the verdict within a short time, orally, then I believe the judge will choose to do that. However, some verdicts can be long, stretching to dozens of pages. Rather than having the two parties and the counsel being kept in the court to listen to the judge, I think it would be better and more efficient for the verdict to be delivered in writing, and the verdict would be available to all. Of course, the two parties, in most cases, would have legal representation, and their legal counsel will help them understand the verdict.
Tam Yu Chung. Mr. Chair, I am not familiar, and I would like to ask the following question. For certain cases, they may be more straightforward, others more complicated, and perhaps the judges themselves will have their own personal styles. For some judges, the verdicts may be very lengthy, and they may bring in many other considerations. Many others are more succinct, and therefore there are different scenarios. If our intention is to come up with a way that is applicable across the board, this may be controversial. To my mind, if at the time of delivering the verdict or the reasons for the verdict, if the judge would take a day, an entire day or many hours, and the counsels are sitting there listening to the verdict being delivered, but at the same time collecting money, and in fact, after listening for hours, perhaps the gist of the verdict would not be understood right away, even if it's delivered in orally, then perhaps after the verdict had been prepared, a written delivery is admissible. Now, for verdicts which cannot be delivered until some time later, then is it possible that the verdict in both Chinese and English can be delivered to the litigants concerned, and can we actually be able to achieve that so that the litigants can leave the court with certain assuredness and certainty? Mr. Chair, first of all, the verdict will not be delivered simultaneously in Chinese and English, and if indeed the written verdict is opted for, that is, if the verdict in written form has already been prepared, then a time will be appointed for the delivery of the verdict, and the two parties to the litigation can refer to the verdict or reasons for the verdict. Mr. Chair, I've heard of situations where the written verdict and the reasons for the verdict will be delivered to the parties. Well, those are civil cases. We are really focusing on criminal cases now. Is that not so, Mr. Lee? Mr. Chair, just a point of supplement. Yes, the district courts for civil proceedings, there is already this flexibility. Just as Mr. Lee had pointed out just now, the judge can consider whether certain cases, because of the certain factors and considerations, less time would be needed, and therefore the oral verdict will be done away with. And there are other courts, for example, in the appeal courts, the judge would also have the flexibility, as mentioned just now, because of factors such as complexity of the cases, the will or intentions of the parties to the litigation, whether there are lawyers representing, etc. There can be this decision of whether the verdict can be delivered in written or oral form. And also we have talked about the availability of the verdict on the website or at the register. Now, if there are problems with language, well, mostly the judges will be preparing their verdicts in English. If the litigants are not familiar with this language, then we will have interpreters who will be able to translate the verdict into a language familiar to the litigants for their understanding. And where necessary, or if requested, the verdict can also be translated into Chinese because of certain grounds, such as importance of the case. It can be considered, the judge can provide an actual readout of the verdict in Chinese. So there are such flexibilities. Now, in terms of timing and duration of the reading out of the verdict, it does not take all that long, usually less than 1 hour for the delivery of the oral verdict. Well, the members talked about public education just now. That is allowing the public to understand the reason for the verdict. And usually the judge would deliver the oral verdict before they come up with the written verdict, unless it is very time-consuming to deliver the oral version, and therefore the judges consider providing only the written. Mr. Ronnie Tang? Well, Mr. Chair, I think it is a very reasonable request. I do not understand why Mr. Lee says that this is not possible. I mean, the CFA is already doing this. I mean, providing the Chinese translation or version. For the district courts, I would think that that is even closer to the everyday lives of the Hong Kong people. And therefore, I think there should be this flexibility. For long verdicts or reasons for verdicts, there can be a summary of the verdicts delivered by the judge orally at the court. And I think that would be better for the assurance that justice is done and seen to be done. Yes, exactly. Mr. Ronnie Tong is correct in saying that the CFA already provides Chinese translations of the verdicts, and also for the British Supreme Court, they do provide summaries to help the public understand complicated matters or points of law, such as constitutional related points of law. According to my understanding, the summary is not prepared by the judges, but there are a team of other professionals helping the judges. As for lower courts, lower court judges, if they are to prepare the summaries as well, that is, prepare the verdicts as well as the summaries, I think it would present a lot of work burden. But this is a great idea, but on the other hand, if you do not have sufficient support for the judges, it will be very difficult for them to take up all that work. So this pertains to resources allocated to helping or supporting the judges. This is directly related. Mr. Lee? Thank you, Mr. Chair. For the summary arrangement, this is only applicable to the CFA. And the reason why there should be summaries for CFA verdicts in our minds, it is because the CFA would usually deal with more complicated cases, and it is not necessarily true that members of the public or journalists would understand the verdict or the reasons for the verdict or the case details itself, and therefore we have come up with this arrangement of a summary for the verdicts. But at present, we do not have the intention to make this arrangement, extend this arrangement to other levels of court. Ms. Chair, you mentioned resources available. That definitely is one consideration. And also in this round of amendment of the ordinance, we are really focusing on whether the reasons for verdict is to be delivered in writing or orally by the district judge. That is either oral or written. if it is in a written form for the delivering of the reasons for verdict, we do have certain resources and support for the litigants, for them to understand the import of the verdicts. So at present stage, we do not think that there should be a rigid arrangement or practice for the judge, district judge, to have to prepare a written verdict as well as a summary, because a summary will definitely not suffice and will not take the place of the written verdict. Thank you. You see, Wing? Mr. Chair, I heard just now that the delivery of the verdict orally would usually take less than an hour, and usually the judge would read out the verdict. And 1 hour is quite acceptable, but there were cases you mentioned where it takes a day or maybe even 2 days for the delivery of the entire verdict. And this is very difficult for the media to report on. Do we set a line, for example, after however many words to the verdict, there would have to be a summary? Well, I also understand that a lot of resources has to be involved. And if the case is very complicated and it takes more than a day to read out the verdicts, then given the complexity of the case and the length of the verdict, it will be very difficult for people to understand the two. So perhaps we can draw a line at a certain word count over which the judge will have to prepare a summary so as to facilitate understanding by all. And if nobody reads out the verdict and the litigants and everybody else are left to read the written verdict, I think this is not ideal. I think there should be certain guidelines as to when there should be oral delivery. Mr. Chair, I think this goes beyond the amendment proposal or intention we have in mind. If over certain word counts there will have to be a summary verdict, then we are not only talking about district courts. I think this will have to apply or may have to apply to the High Court as well. But really, we are only focusing on how the verdicts are to be delivered, in written form or in oral form. If the former, it does not equal that the litigants would not understand them. Now, just from a discussional point of view, if the media are to sit in the court for 2 days and listen to the entire verdict being delivered in order to understand the judge's reasons for the verdict, well, that, as opposed to having on hand a written written verdict or reasons for verdict, I think the latter would afford more understanding into the import of the verdict, I would think. Mr. Chair, well, I'm thinking about the district court. From my experience, I think the judges should be given more leeway and flexibility as to how they want to deliver the verdicts, because too often everybody sitting in the court listening to the verdict is not meaningful. And for certain judges, they have the practice of not or withholding the final decision until the very last, and people are left in suspense for 2 days, and that is torture psychologically. But other judges actually deliver the final judgment first before reading out the reasons for verdict, but that seemed anticlimactic. So, but what is most important is the resources. With so many senior counsels, etc., sitting in court listening to the verdicts, and where there are a lot of litigants or defendants, the costs is stupendous. So, going back to the CFA, we know that for most of the jurisdictions, or the great majority of common law jurisdictions, there will have to be a highest court giving leave before there can be appeals brought to it. But I would like to know about our past historically. Before there was the Supreme Court Act in the UK, and there was a Privy Council, the House of Lords, the amount, that is in monetary terms, was used as a determinant as to whether there is or is not a right of appeal. This financial limit was described as arbitrary and not right for the modern world. I can understand that, but historically that was the basis. Is there anything that we have not referred to in terms of documents or others that we should refer to before we make the decision? This is really not about the CFA wanting to cut down the workload, because they do spend a lot of time deliberating on the cases anyway. And for the Singapore case, for example, there are only 2 levels to the court, and therefore their High Court will still retain the financial limit because there are only 2 levels to their courts. But in Hong Kong, there are 3.
$1 million is a small amount, and 3 levels of courts would mean a lot of pressure to the parties involved. Can you let me know the historical causes to such a proposal? Mr. Lee, we could not find any historical causes. The only thing we understand is that before the reunification, we would take cases to the Privy Council. And at that time, there was this as of right mechanism. When we formulated or drafted the CFAO, we made the decision to preserve that mechanism, but we only lifted the amount from $500,000 to $1 million. When we worked on this present exercise, we took a look at the UK, Canada, Australia, and New Zealand, and such common law jurisdictions, and indeed, we found that they have removed this automatic right of appeal. In those jurisdictions, their Supreme or High Courts will have to actually give the leave before cases can be the subject of appeal. The only exception is Singapore. Now, Singapore has a different court structure from ours. And basically, at present, we have the Court of Appeal at the High Court. So, in our structure, and indeed, the CFA said in a few case laws that our present CFA is not a second court of appeal. We don't want to position the CFA, its nature and function as a second court of appeal. So from that angle, we believe it is necessary for us to remove this as of right mechanism. But compared to Australia and New Zealand, they apply more or less the same principle that the Supreme Court would have to grant leave for appeal. But the factors for consideration are more encompassing, including what we say here in Hong Kong, a great general or public importance, but they also look at whether there will be judicial injustice. And then in New Zealand, you also have to consider whether the case is of a general commercial significance. And these are also parameters for the Supreme Court there to consider whether grant of leave to appeal should be made. To some members of the public, maybe those cases do not have anything to do with them, but they are interested in those major cases. So perhaps we can also write more guidelines or parameters so that you can allow the CFA to consider a bigger basket of factors. Thank you, Chairman. We understand that in New Zealand, indeed, they mention the factors such as general commercial significance. But to a certain extent, the right of appeal is still somehow linked to a commercial amount. Say if the case has to do with commercial matters, and if the amount involved is higher, then it seems there will be a bigger right of appeal. This is what we don't want to see. So on the 3rd of December at the AJLS panel, when you went to have a meeting with the chief judge of the CFA, the chief judge explained to you on that occasion that we did not want to follow the example of New Zealand. At present, we of course have this factor of great general or public importance, and in fact in the ordinance we have this tag or otherwise, meaning other reasons, which the CFA can also consider for the grant of leave to appeal. If the two are taken together, the CFA does have enough latitude to process such applications for leave to appeal. The cases may not comply with the first leg, which is great general or public importance, but then the tag or otherwise will then kick in. The law doesn't expressly specify what is meant by or otherwise, but exactly how the CFA is given a wide range of discretionary powers. Can I have a short follow-up, Chairman? Talking about this tag or otherwise, you can call it the other limb. Well, I'm not an expert on CFA cases, but my impression is that it's very difficult for people to be able to trigger this. I don't know in history how many cases have been given the leave to appeal according to this particular principle. My understanding or memory tells me that this is rarely used. So if you have cases, please let me know. And talk about New Zealand. They have the general commercial significance factor. Is it really like what the Deputy Judiciary Administrator said? Do they only place emphasis on the dollar amount, or do they also look at commercial practices or important disputes? My impression is that it is not just about money. Even if it is just about money, and of course it's not just $1 million, which is a very small amount indeed. If you're really talking about $100 million or even more, then I would say that only very arguable cases will go to an appeal court. So in very clear-cut cases, the people will not take them to an appeal court. Well, we have heard the personal view of the chief judge, but if you look at the general or public interest, let us stand back and be objective about this. The dollar amount is or can be an objective criterion, but let us strike a balance and please answer my question. Were any cases granted leave according to that limb of or otherwise? Chairman, we don't have the figures, but indeed, in the past, grant of leave to appeal has been made according to this other limb, so that the appellant could take a case to the CFA. Just now, Mr. Chair and some other members have asked about this other limb of S or otherwise. Now, compared to other jurisdictions, I think this is such a vague construction because you don't beef it up with what factors should be considered. We of course understand that it's up to the judge to exercise discretion, but usually when discretion is exercised, the law would usually say which factors should be considered. I think Mr. J and other members are worried what is meant by or otherwise. So could you tell me any case law where the CFA has indeed interpreted this other limb or otherwise? If indeed you have such case law, please let us have it for reference. I don't have it at hand, Chairman, but we can try to look it up and let you know next time. Well, if you do have such case law, will be so much reassured. If you look at Australia, Canada, New Zealand, their law provisions state what factors have to be considered. So if you just say as or otherwise, I think the public will still be worried. This is my own view. And I think, well, I don't think any member is standing in the queue. I am. Okay, Priscilla Leung, Chairman. Our social development is such that I would understand why it's not easy to peg the as of right mechanism to a financial limit. I have dealt with different cases, and the parties would think that they have been dragged along by the other party which has the means, and this is what you mean by a delay. And in fact, the other party which has the means can in fact abuse the entire process. I think I can understand that very well. However, in the exercise of discretion, it is also the social trend that even at the CFA, there could be judgments which had to do with general public importance or of general public interest, like the W case. In other words, the public would be very interested in such major cases. So I'd like to ask you these questions, which other members have also asked. In another part, you say it's up to a district judge to deliver the verdict orally or in writing. Now, my own inclination is that you also set some criteria for that. In fact, people around me have said that whether the judgment or verdict is long or short, that definitely has to do with the parties involved or the issues involved. It may be a simple case, a simple crime. However, because the person involved is a very famous person, so the verdict may be long. Therefore, I would say that you should write some criteria down. However, that would again cause criticism, because some people would not like the judge to read out the verdict, especially if it is a famous person in society. Some people would say, oh, just hand down the verdict instead of reading out the verdict on me for 3 hours, because that would attract a lot of media interest. And they would say why the other verdict is just 15 minutes long and mine is 3 hours long. So I believe the discretion can be exercised by the judge, but then you should write down some criteria so the public can understand how that discretion is exercised. And also, talking about the discretion to grant leave to appeal, I myself have worked on certain cases, and I know that it's so difficult to seek leave to appeal. It is also very costly. We need to hire a senior barrister just to get the leave to appeal. You have to make very serious preparation for it. And we must admit that if you are given this amendment, you are enhancing the threshold by a wide margin. So if there may be more criteria behind this, as I said, we should look at the issues involved. If it is of major public interest, then there should be some criteria that should apply. In other words, the judges should follow certain direction. Because if it's just pure discretion, then what ensues may not be beneficial to the court, because there may be a lot of repercussions in society. And then we'll receive complaints because the public don't understand why somebody is not given the same treatment as others, because judges have exercised discretion. So why don't we give more consideration to criteria which may apply? I believe this was also mentioned in the panel. And that is whether we can make it clearer for the public how judges would exercise discretion. I think this is one of our concerns in considering whether we would allow you to pass this amendment bill. Any supplement? I have heard members' views, but actually, at present, the major criterion is great general or public importance. This is what the law states. Now, if we look at the law, it has this tag, or otherwise. The chairman asked for information and case law to help interpret this. We have said we will go back and seek some understanding and come back to members at the next meeting. As for the district court and verdicts, whether it should be oral or written, or whether discretion or criteria should be written for that, we have heard you. We will have to discuss in-house, and then we can tell you our position next time.
Yes, Mr. Chair. I'm looking at part 5 there, 3, concerning televised link. In the Chinese version, you have a very long explanation. In English, you say audio-visual facilities. Very short. Why is that? Can you please explain? You're looking at C2634 and 2635. Yes. Ms. Ng, or is it Mr. Chan from the Government Council Department of Justice? Yes, this is an amendment of an ordinance. So we cannot just only refer to the blue bill. You said that the Chinese version seems to be long and the English very short, but rather we have to look at this in conjunction with the with the criminal offense procedures and procedure ordinance. The Chinese seems to be cumbersome and may not be all that clear, and we would like to take this opportunity to rewrite this definition to make it more succinct and clearer so it facilitates understanding. And the effect after that exercise will be the same as the English, but the wording in the Chinese may be different. And therefore, in the amendment ordinance, it seems that the Chinese is lengthy and the English is short, but in fact the legal effect would be the same for the two languages. Mr. Chair, perhaps the Secretary can do a comparison table. And we're looking at the Chinese wording, which has the same meaning, but after the amendment, it is clearer, but the legal effect is exactly the same. Ms. Leung Mei-fan, Mr. Chiao Wei-chen. Mr. Chair, just a follow-up point. Section 221. We mentioned, or we heard, that the amendment is very limited. That is because of technological advancement. We can have other remote technology available, not only CCTV, but for sexual cases, victims or sexual violence victims of those cases, in order to be able to use this technology or mechanism. There are three types of people. Yes, children or underage persons, we understand. For the mental disorder persons, yes, all we need is a professional letter. But witness in fear seems to be very subjectively defined by the judges, and very often, even with application, the prosecutor would not be very cooperative. while we have this opportunity of amendment, perhaps we should also take note of this situation. Where appropriate, should we, for the concept of witness in fear, define it more clearly so as, or at least have victims of sexual cases to provide more privacy and protection for them? Of course, all will have to abide by the principles of justice. Yes, we're looking at 221 amendment. We are basically looking at it only from the point of view of audiovisual technology. And Mr. Jie's point really falls outside of the ambit here. Of course, if we are to follow up with Mr. Jie's point, we will need consultation and we'll have to approach it very carefully, and it would be unlikely that we'll be able to deal with it in this round of amendment. Mr. Chair, I think Mr. Lee would not object to my claim that this has been controversial for a number of years. And in fact, the commissioner, the previous commissioner, had been very concerned about this and invited views and opinions on the hearing of evidence for such criminal offences. I cannot believe that while you can change the CFA related cases to such an extent, but not take the opportunity of changing the or providing more protection to victims of sexual cases, but only limit yourself to the technology, whether it be Wi-Fi or whatever. Well, I think Mr. Jie raises a substantiated point, and that is protection for victims of sexual cases. We have discussed that at different occasions and a number of times. Should we not take the opportunity and the right opportunity to change or amend this? I think the administration should consider it. Yes, Mr. Chair, we are talking about wide-ranging amendments to the CFA-related cases, and this is really something much smaller in terms of scale in comparison. Should we not take the opportunity to amend it? Mr. Chair, this ordinance for this round is really about the judiciary and its operations of the law courts. And what Mr. Jie referred to was really about something more complicated and bringing up different opinions. And I do not think, therefore, that his point should be considered or followed up in this occasion. Mr. Lee, you have not understood my point. The CFA amendment is not without controversy. Mr. Ng, Mr. Tong had raised their concerns. Now, you want to go ahead with it regardless. But on the other hand, you have heard a lot of opinions on exactly the point that I've raised. Why do you not seize the opportunity? And, you know, this is not a LICO opportunity, but this is something that's fundamental to the basic law, even by amending the CFA-related situation. Or perhaps you are not thinking of advancements. You are turning a blind eye to the welfare of the victims and the people concerned, unless that is the reason. Well, for the right of appeal to the CFA, we have certain procedures. We've gone through the panel, and we have the panel's blessing before we come to this particular meeting for the bill and the deliberation of the bill. We do not take this process up without due process. We are bringing this to the LegCo on that particular due process. As for Mr. Jie's suggestion just now, it seems to me a follow-on on an existing topic that is being deliberated. And in my terms of reference for this round, I cannot take that up. That's what I'm saying. Mr. Chair, I understand that. Of course, there has to be due process, but we have discussed this topic in different occasions and many times. Or perhaps you're saying that the big boss asks you to do something and you just follow his orders and disregard the others. Well, I will not put you in a hard place today, but I would urge you to go back and put in the same kind of efforts that you are pursuing the CFA amendment for this kind of, for the topic that I've raised. Mr. Chair, I think in this meeting, it will not be taken up. The topic that Mr. Tse had raised just now, which had also been discussed in numerous rounds of the panel meetings. I have raised the same. When the JS came to the meeting last time, apart from the chief judge of the CFA and himself, who can make changes to the legislation, amendments to the legislation. I remember I raised at the meeting a certain point, and I remember there was a member who's not at this in this committee. And on the 3rd of December, he himself actually raised it in person to the chief judge of the CFA, and the chief judge said that they will go back and think about it. And after that, we had depositions, and pursuant to that, I have written to the chief judge to say that we are, the committee or the panel members are highly concerned about this topic and this point. In fact, we have discussed this point, but we have, that is the point of the screen, or the topic of the screen for witnesses and victims, and we have heard the depositions. But on the other hand, the defendant lawyers are not all consistent in their views. But I think the members feel that this can be done, that it can be achieved. But of course, the lawyers may want it differently, because if they can exert more pressure to the witness or the victims at the time of the hearing or the court procedures, they will win the case. But to our minds and in the public interest, we are asking for a screen for the witness, so that when providing the evidence by these witnesses, they will feel more at ease and more protected. Now, this is a very specific suggestion on our part, and we have raised it before. Members of the panel, in particular certain members of the panel, are particularly concerned about this point. I know, as chair of the panel, that they have followed up with me time and again, and I have personally written to the chief judge. I would urge you to be very serious in consideration of this when going back. We have already touched on this topic, and we have heard questions as to why we have not followed up on it. And in fact, members of the panel have also raised the same point, and that is why we have not followed up with it. So we have a great responsibility here. This is not a small matter, but for members of the panel, in particular for those who are not from the legal field, they feel that their opinions are not being respected. Mr. Lee, any supplements? None. Anybody? Colleagues? Yes. I have a few questions to ask. Many members have spoken up, and I have to say I agree to them, and in particular for the CFA, for the right of appeal. I am personally concerned that this may not be an erroneous policy direction. Yes, indeed, you have dealt with the $1 million financial limit, and why not 999,990? etc. Yes, and this is arbitrary. But for the right of appeal or otherwise the tag, do please go back to look at what the CFA had expounded on in terms of or otherwise, whether there is something that we can refer to or whether there is none, or whether the CFA has very wide-ranging liberty as to treat that or otherwise. I would believe Australia and New Zealand as other common law jurisdictions are clearer in their demarcation of that is or otherwise, quote unquote, and how it is to be used. Other questions, smaller but worthy of attention. 336, District Court Ordinance, Section 336. You are proposing written verdict only, but I'm looking at 6ABC. You have not specified that these must be uploaded onto the website. You said that the verdict will have to be lodged with the library, had to be delivered to the litigants, parties, and the public will be able to refer to them in the office of the court. But what about uploading onto the internet? Because we know very well that more often than not, the verdicts are referred to or looked at through the internet.
Mr. Lee, do you have something to say about uploading the verdicts onto the website? At present, we have already done it, but we don't actually do it according to a particular law. CFA and High Court verdicts are uploaded to our website, but we don't do it because we are required by the law. When the legal year was opened, the Chief Judge has said that when we look at the openness of our judicial system, we have this administrative measure whereby verdicts can be searched and accessed on the website of the Judiciary. So this is not a legal requirement, but on different occasions, we have stated why this is important, and the judicial administrator does make sure that we would waste no time in uploading verdicts onto our website. Let's ask you the question. All High Court judgments, including the Court of Appeal judgment and also District Court verdicts, including civil and criminal, they're always uploaded to your website. Is that right? Yes. Now, if that's the case, then why don't you turn it into a legal requirement? We'll have to look into that. As I said, this is not just CAP 336. If you want to turn this into a legal requirement, then we may be venturing into a bigger scope. Okay, we have raised many questions and we have asked for figures and data. Mr. Lee, please give them consideration when you go back, and we can discuss these at our next meeting. The clerk reminds me to ask members whether you would like to receive deputations. Actually, when the AJLS panel discussed this issue, we also asked whether we should do it. Maybe we can ask the Labour Advisory Board, and we can write to them to invite them to submit their views to us. And also, our Legal Service Division has written you a letter dated the 23rd of May. Please reply to us. Yes, we did. We are preparing a reply. Any other questions or issues? If not, we will meet again at the next meeting. Okay, thank you very much. Thank you.